Okay. Not eligible? I didn't
She's
actually.
not on.
Actually didn't write that down.
There's door. And
We're running district court at the same time.
Gotcha.
It's
So
just,
sure she's got all our initial cases here, so let's we'll have to wait until he's freed up from district court. Mr. Trish, were you ready on Mr. Butt's cases?
Yes, Your Honor.
Okay. People versus William Butts, case number 204727 and 39 record should reflect today.
Your Coke, half the people.
Thank you, Your Honor. Richard Trushbury on behalf of Mr. Butts.
How do we want to go forward today on these probation violation matters?
So, Your Honor, we would at least be requesting one more adjournment. I know it's been adjourned a couple times pending the trial. Our trial dates are at the end of March, I think the 24th and 25th. So the trial is coming up here pretty quickly. And, well, we do expect it to be going to trial. I don't object, Judge.
All right, I'm going to adjourn these out until April. That'll be our next hearing. And Mr. Trush, obviously, if something happens on the other matters before that, I'll just ask that you, yeah, they'll be aware of it, but you can find it forward, we can set up for hearing sooner than that.
Certainly, there is one disclosure I do need to make. When reviewing the file for today's hearing, I did discover that the alleged victim is a former client of mine. I don't think it presents as a problem, but I just want to make the disclosure to the court.
You're aware of that, Mr. Fox?
Yes, sir.
All right, thank you. People versus Boswood, case number 245345.
Your Coke on behalf of the people.
Thank you, Your Honor. Richard Trushbury on behalf of Ms. Boswell.
Podium there, the record should reflect Ms. Boswood is present here in the courtroom today. This is the date and time set for a sentencing hearing in this case. Ms. Boswood, have you had a chance to go through the pre-sentence report and talk to Mr. Trush about that? Mr. Trush, are there any additions, deletions, or corrections?
No, Your Honor.
Challenges to the scoring of the guidelines?
No, Your Honor.
One question I had, I know that 7411 was discussed as part of the plea. I don't believe Ms. Boswood was eligible. So is that part of the agreement? Is that something that we need to address?
So at least from our perspective, I have discussed with Ms. Boswood. She understands that she's not going to get the benefit of that because she's not eligible. I don't think she intends to withdraw her plea or changes anything that she wants to do.
All right, Ms. Boswood, have you discussed that with Mr. Trush?
Yes, I am.
And do you still want to move forward with sentencing today? What's that?
Yes, I do.
Okay, thank you. Ms. Cope, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No.
Anything on behalf of the people for allocation today?
There were more docket entries on her criminal history in the PSI than there were on her CCH, which frankly is kind of concerning, but it's a lien issue, not Ms. Boswood issue. She presents at 63 years old. She had methamphetamine. She will not get the bargain of 7411, which is a pretty significant loss for her because of her previous history and some auto set-asides that are just listed as dismissed. The recommendation is 2 years in probation with no upfront jail. I spoke to Mr. McFalda. It's not very often that we see people getting no upfront jail on their fourth felony recommendations. He indicated she was very forthright about her issues. She was very honest with the police, and he thought that she might have a chance at rehabilitation. Her last drug case was almost 2 decades ago. So I just asked the court to follow the recommendation.
Mr. Trush?
Thank you, Your Honor. I agree with much of what the prosecutor said here. Ms. Boswood is someone who hasn't really had any significant interaction with law enforcement in the last 20 or so years. So I think that in and of itself speaks volumes. She recognizes that she's had problems in the past. She had a long period of sustained sobriety. I think she's going to talk to you a little bit more about some of the sort of events that led to the relapse here. But frankly, that's what it is. It's a relapse. And she's had a very significant period of time of sobriety, good time between her last interactions and this. I think that a probationary sentence is appropriate to give her an opportunity to re-engage with sobriety, with the supports that she needs.
I just really want to apologize for my relapse, especially to my family. My significant other was dying. He actually ended up passing away on November 11th, but he had been critically ill for a period of time, and I guess my biggest thing was knowing how to deal with situations. Never been, so I need to, and that's what I'm doing now, is that I'm in counseling for coping skills rather than running to drugs.
All right, I read through the report, so I'm familiar with the case that brings you here. There's also a lot of information in the report about your background, your circumstances. And I take all of that into account, what the lawyers have had to say, what you've had to say. I do think the recommendation is appropriate. I think this is a case where we need to focus on rehabilitation, addressing the issues that you've indicated. Certainly, those circumstances are something that I think it's reasonable to expect that it could cause a relapse when you're dealing with something like that. But I think the key, as you've indicated, is finding healthy ways to deal with those issues that we all face from time to time, no matter what. So I think, given the significant period of time between the previous offenses and this offense, I think, yeah, rehabilitation or sentence is called for. So I am going to follow that recommendation, with the exception that I am going to hold some jail time in advance. Because number one, I think, given your past history, having that held in advance is appropriate and reasonable. But number two, I think hopefully it'll provide an added motivation for you to comply with the motivation. And because we're tailoring this as something designed to address rehabilitation, if you're not following that, then I think the other alternative is the punishment aspect. So the court is going to sentence you to probation for a period of 2 years. The court's going to adopt, as the conditions of the probation, all the terms and conditions listed in this report. And in particular, of course, that you not use or possess any controlled substances unless they're prescribed to you, and that you comply with and complete any kind of substance abuse counseling or other treatment that's recommended to you. The court is going to impose 3 months in the Crawford County Jail with credit for 1 day served. I will hold that time in advance, so if you comply with probation, you never have to serve that time. If you don't, however, the court can impose any or all of that time immediately up front. Will also be ordered to pay a crime victim's assessment of $130, court costs of $325, attorney fees of $350, $68 state cost, and supervision fee of $30 per month while you're on probation. You do have the ability to seek an appeal of this sentence. Ms. Boswell acknowledges. Yes. So just touch base with Mr.
Thank you.
Murphy, you ready on Mr. Prentice?
I am Judge.
People versus James Prentice, case number 235153. The record should reflect Mr. Prentice is present here in the courtroom.
Sierra Coke on behalf of the people.
Thank you, Mr. Prentice.
Today was set as a probation violation hearing. Mr. Murphy, tell me how the defense wishes to proceed.
Mr. Prentice is going to plead to 1 count on the probation violation summons dated 10/3 2024, that on or about 9/30 of 24, he used methamphetamine, and then would also plead to another count of use of methamphetamine on 1/9/2025. The remaining counts will be dismissed on the warrant, and then this will be set for a formal sentence.
Mr. McDowell, is that the offer of probation?
That's correct, Judge.
Mr. Prentice, have you had an opportunity to speak with Mr. Murphy about this?
Briefly, yes.
Did you need more time to do that?
I don't think so.
Is that how you wanted to proceed?
Yes.
Raise your right hand. Solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Prentice, you understand that you do have the right to have a hearing as to whether or not you did violate your probation? And you understand that by pleading guilty to these two violations, that you'll be giving up that right?
Yes.
Also, by pleading guilty, you're going to be subjecting yourself to the maximum possible penalty charge here, which is delivery. Is this 4 years?
A 20-year judge.
So that would be up to 20 years, you understand that? With all of those things in mind, what are your plea to those violations today?
It's guilty.
Has anybody threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here in court today? Is it your own free choice to enter this plea? Are you pleading guilty because you did violate your probation?
Yes, I did drop dirty.
Back on September 30th of 2024, were you on probation here in Crawford County?
Yes.
And were you aware that one of the conditions of your probation was that you were to not use or possess any controlled substances? Did you use methamphetamine or possess it on or about that day?
Yes. And that's why I went to rehab.
Also, back on January 9th of 2025, were you still on probation?
Yes.
And you were still subject to the same condition that you were not to use or possess controlled substances, is that correct?
Correct.
Did you use or possess methamphetamine on or about that day?
Yeah.
All right, the court finds that your plea is knowing and voluntary and accurate. The court is satisfied that there's a factual basis to support a finding that you did violate your probation as alleged. The court will accept the guilty plea. And we're gonna have this set for separate sentencing date.
Yes, Judge, that's it. They did prepare a violation report.
Okay, so Mr. McDowell is gonna meet with you, prepare an updated report, and then we'll set this matter for sentencing hearing. Can you be notified of the date?
Am I allowed to talk? I just want to say that I'm really sorry to myself, mostly because I relapsed once again. I was trying to do the right thing. I was really trying to, yeah, I know I have a problem and it's not, you know, the whole dealing it or nothing. It's the consuming. And that's why I wanted to go to rehab, you know, on our first hearing here. And when I got out, I went home and there was another person in the house and I was trying to get them out. And just before they ended up leaving the house, I ended up using, and I knew that was my problem. You know, I knew that was going to be a bad idea. That's why I was trying to get them out, and I still ended up messing up before I came to see you. And I really would like one more chance. That's all I ask, is just one more chance to try to get this right. And I really would like one more chance.
I'm assuming Mr. Prentice is asking the court to consider a bond in this matter, between now and sentence.
What we're gonna do is I want to see the pre-sentence, the report that Mr. McFalda prepares. I want to see where we're at with this. I always, in these kind of cases, I always consider rehabilitation as a potential outcome. So I will absolutely take your request into consideration.
Thank you.
Thank you.
Mr. Law is present as well. It's a district court matter.
Okay, Mr. Law, you come forward. We've got two different files up for hearing today on Mr. Law's case. file number 25177772 FY, which is a case that's set for probable cause conference today, and then we have 417615 SM. I'm not sure what that is.
Probation violation.
Okay, so the record should reflect Mr. Laws here at presiding over these cases by assignment. By contempt counsel for your.
Sierra Coke on behalf of the people.
Thank you, Rev. For working with you, Mr. Law.
So Mr. Gurmurthy, how did you want to proceed?
Just, I'd like to bind the new file over into circuit court and adjourn the probation violation, and we said that at the initial jury status conference. And that way we'll have everything in front of you, so we'll have the new file properly docketed on the circuit court docket, and then piggyback the probation violation, because that'll resolve it once there's a resolution, once we bind it over. So I'd like to do that at this point.
Okay, let's go.
Yeah, I would have no objection. I'd ask to be able to file the information this afternoon. I didn't have this on our docket. I think I'm handling it. Just things are moving around in 2 different courts right now. But we don't have any objection to that, and we'll get the information filed today that will mirror the complaint.
Okay, so Mr. Gurmurthy, if I could file the waiver.
I can file a waiver of the arraignment if the court wants to do that, and then I'll again acknowledge the felony information as long as it mirrors what the complaint is once the court's office gets it to me. So we will waive then the reading at that point and have enter a not guilty plea at this point on behalf of Mr. Law, and then we'll just reset this on the circuit court.
All right, and then in terms of the probation violation, same thing you said, that I got it as an arraignment, so Mr. Law reading that violation.
My understanding, he was arraigned previously, but if you have it as an arraignment, I would then ask that you again waive reading of the allegations in the probation violation report into a not guilty plea. We would again waive our right to have a hearing within 14 days on the PV file and set it simultaneously with the circuit court matter now that it's filed over.
Yeah, it looks like he's not been arraigned on that.
Or I would accept what the defense counsel is requesting at this point.
So the court will enter not guilty plea with regard to the probation violation. Particularly circuit court felony probation violation, we set bond. I don't know if that part of the.
Bond was, I believe, set on the felony matter. I don't.
Right.
But I don't know about the probation violation matter. I would ask that the court, at least on, there was a hefty bond on the felony matter, that the court, at least on this file, just set a PR bond. There's no issues of non-appearance, no prior history. And my understanding was that he was arraigned when he was in jail for both matters. I was not really prepared on the arraignment, but I was under the impression both were done at that same time.
All right, let's go.
Yeah, I'm reading the district court notes from the APA. It doesn't have any notation as to bond.
Then as to the probation violation file, the court will set that $1,000 PR bond. Assuming that. Okay, so part of the conditions of probation is the no contact with assault. That's the basis of the alleged violation. So, Mr. Law, you're continuing to be under the condition now as part of the bond, but also part of your probation. Not have any contact with that individual. Okay.
Yes, sir.
Ms. Koch, anything further that we need to address today on either of these?
And my staff did just bring me the information. Witness may exhibit list and demand for disclosure. I can tender a copy to defense counsel and the court.
I'll acknowledge receipt, Judge, as I previously stated, and waive formal reading, and I would ask that you enter a not guilty plea on behalf of
The court will enter a not guilty plea on behalf of Mr. Law for purposes of certain court arraignment. 525177772.
Thank you.
Any further?
No, sir.
And for the record, we do not object to the waiver of the preliminary examination. I think I have to say on the record, so I'm saying that.
All right, thank you. That's all. Thanks for that.
Thank you, sir.
Thank you, Your Honor.
This matter is Mr. Saylor's case. Short recess when Mr. Church is available. on the record now in versus Michael Saylor, case number 245346. Record just reflects Mr. Saylor's present here in the courtroom. If I could have counsel take your appearances on.
Sierra Folk on behalf of the people.
Thank you, Your Honor. Richard Truth, appearing on behalf of Mr. Saylor.
Thank you. This is the date and time set for a sentencing hearing in this matter. Mr. Saylor, did you have a chance to go through the pre-sentence report and talk to Mr. Trush about that?
Yes, I did.
Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring guidelines?
No, Your Honor.
Ms. Cope, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution?
This is one of those cases where you look at it and you think to yourself, Mr. Saylor's lucky to be standing before this court today with no one having been injured. I mean, he's doing 106 miles per hour on the highway. He's at a .276 and a .281. He has 3 prior drunk drivings. This is his 4th, I believe. He attempted to go to rehab, but he left after 3 days. Essentially, he has done nothing to help himself in any way. And it seems like just a series of one bad decision after another in Mr. Saylor's life. I'm hopeful that he uses the time that he has in the jail to reflect on these decisions. I think the recommendation is fair, 10 months up, 10 months of jail, 8 months up front. And then if he wants to attend rehab for the last 2 months, I think a rehabilitative goal should be important for Mr. Saylor as well as for society. I ask the court to follow the recommendation. Thank you.
Mr. Church?
Thank you, Your Honor. I disagree with some of how the prosecutor framed the case here. I mean, certainly what Mr. Saylor did here was a bad decision. It was dangerous. I don't agree that he hasn't done anything to help himself. He did get out and fully comply with the requirements of community corrections, including testing. He did those things. Yes, did he go to rehab and didn't stay there? That's accurate. The reason he didn't stay there, though, was they wanted to use medically assisted treatment for him. He did not want to do that. He didn't want to substitute one substance for another. Certainly, we could debate whether that's the right decision or not, but that's what happened. He was open and honest with me in terms of what was going on there when he left there. He communicated that to me. I think that it is not an inappropriate decision for him to make. It wasn't the right fit for him. Since then, he has been looking into the Lion's Den. We don't have a bed or like a start date for him there because we did anticipate upfront jail here. So we didn't want to get him into that program. I would ask court to consider allowing him to go into that program at some point during the jail sentence. The court's probably a little bit familiar with the Lion's Den program, but it's a long-term program in Roscommon. He attempted to get into the drug court in Roscommon, but they won't accept transfers. And because this case is here, they just simply told him no. He didn't have another available option there. I think the Lion's Den would meet his needs. I think it's something that would provide him with structure and the support that he needs. So I would ask the court to consider following the recommendation insofar as the upfront jail, allowing him the ability to maybe go into the Lion's Den or a different inpatient treatment if he is able to find that. Thank you.
Mr. Saylor, anything you wanted to say?
I'm sorry.
I did review the report. There's a few things that stick out to me, not only about the circumstance, but about your past history as well. I mean, on the positive side, it does appear I did receive a report from Ms. Anderson indicating that you have applied with your alcohol testing, remain alcohol-free during pendency of this case. So that's certainly positive. The negatives obviously are your past history. We've been down this road before, been on probation 5 or 6 times, 5 or 6 jail sentences. Here we are again. You're looking at guidelines here, 7 to 23, so the court would be within the guidelines, essentially almost 2 years in prison. And the next time you're before this or any other court, I think you're going to be looking at prison at the bottom end. So this really is your last opportunity to avoid that as a consequence. This is your 4th driving related or alcohol related driving offense. I also know you've got 8 prior charges for driving with your license suspended, so you're continuing to.
I need the right help.
Huh?
I need the right help.
Yeah, well, saying all this to tell you that this is your last chance to get that for yourself. I mean, courts can order it all day long. You know, it's not gonna matter unless you want to make the change. I do agree with the jail sentence portion of this, and there needs to be a likely consequence. Because of the danger that you pose to yourself, and more importantly, to everybody else who is out there with that kind of blood alcohol level. That's high. But I also agree that the rehabilitation component here is appropriate as well. So I think that the sentence is well crafted to provide both for punishment and for the potential of rehabilitation. So I think the recommendation is, like I said, well crafted, and I'm going to follow that. Court is going to sentence you to probation for a period of 24 months. Court's going to adopt as the conditions of the probation, all the terms and conditions listed in the court. The court is going to order that you serve 10 months in the Crawford County Jail. Court would consider allowing you to leave for treatment after 8 months of that sentence. You do have credit for 2 days served. Crime victims assessment of $130. Court costs of $325. $350. $68 state cost, $100 reimbursement for the alcohol testing, $30 per month while you're on probation as a supervision. You do have the ability to seek an appeal of this sentence, and Mr. Trush, if you have Mr. Saylor acknowledge receipt.
We already provided that to the court, moving over it before the hearing.
Is there anything else that we need to address for the people today?
No, thank you.
Mr. Trush?
Nothing further today.
Taylor, you're amended to custody of common prison.
This week sometime too.
Sir, are you Andrew Parrish?
Got it. Got it.
Name Andrew Parrish.
Said you're not muted, so.
They can hear him. They're all looking up at me like something's going on.
Are you able to hear me?
Yep. Yes, Your Honor.
Okay, great. All right, you're Mr. Parrish, is that correct?
Yes.
All right, we're on the record in People versus Parrish. This is file number 245317. The record should reflect Mr. Parrish is appearing today by video from Schoolcraft County Jail. This is the date and time set for a sentencing hearing in this matter.
Yes, I did.
Mr. Parrish, did you have an adequate opportunity to talk to Mr. Trush and go through the pre-sentence report with him?
Yes, I did, Your Honor.
Okay. Mr. Trush, are there any additions, deletions, or corrections to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Hope, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution?
Your Honor, in the PSI, it indicates that Mr. Parrish does not think probation would be effective for him, and it would be difficult because he travels to and from Flint for work and probation. I asked the court to take that in consideration when crafting the sentence. The recommendation is for possession of three prior misdemeanors, 2 years or 2 months in jail with credit for 3 days and no probation recommended. I think that's a little light when there's no probation recommended, but I would defer to the court on that. Thank you.
Mr. Trish, anything on behalf of Mr. Parrish today?
Your Honor, I guess, yeah, I certainly can understand the prosecutor's position there. Can also understand Mr. Parrish's position. He's sitting on a 6-month sentence for violating the probation that he had in Schoolcraft County. That's the circumstances he's in right now. I can certainly understand why he's not eager to start another probationary sentence in a county that really he has limited contact with. From what he's indicated to me, he doesn't plan to be back in this county. He moves around a lot for his work, so I certainly can understand why he would not be, thrilled or eager to have a probationary sentence. The recommendation of jail would seem appropriate. I would just ask for it to take into account his circumstances there, that he's sitting on a probation violation sentence. His lack of criminal history, his history is really limited only to 3 misdemeanors. This is his first serious interaction with the courts. So I would suggest through that lens, the recommendation for a short jail sentence would seem appropriate.
Thank you. Mr. Parrish, anything you wanted to say today?
Yes, Your Honor. I'm looking into going to rehab, and I need your permission to go do that. It's in the process right now, so I don't know when I'll be going exactly, but it's in the process.
Okay. All right. Mr. Parrish, I did review your report. It gives me a lot of information about your background and your circumstances. Also, information about the circumstances of the charge here and kind of what's gone on during the pendency of this case. I would agree that probation is not appropriate here, not really because of any inconvenience it would cause for you, but rather, in my view, the idea of probation is people that live in the community to provide for a measure of supervision, monitor, rehabilitation, and so forth for people that live in the community, and the benefit that it provides our community. And in that regard, I don't think it would be helpful. I also think, kind of your behavior while this was pending, issues with contact. Well, some of that was related to your matters up there. A lot of it was just failure to follow through on your part. I don't see probation as being beneficial to you or a good use of resources by the court. So I do think a straight jail sentence is appropriate. And the guidelines here are 0 to 11. I think a sentence within the middle of the guidelines would address the court's interest in having some punishment for your actions in this case and your pendency of the case, but also recognize some of the mitigating factors here, like your lack of a significant prior history. So the court is going to sentence you to 6 months in the Crawford County Jail with credit for 3 days served. That just be run concurrent with your sentence there in Schoolcraft County. The court is going to order that you pay a crime victim's assessment of $130, court costs of $325, attorney fees of $350, a DNA testing fee of $60, and a $68 state cost. If you can provide documentation or some kind of written proof that you have a bed available at a treatment facility and that the judge in Schoolcraft County is going to release you to attend treatment, I would certainly consider that. So that would be something that you would need to provide either to your attorney, Mr. Trush, or directly to the court. You do have the ability to appeal this sentence. If you haven't already received it, you will be provided with some papers that explain to you what your appellate rights are, as well as how to request a court-appointed attorney to help you with any appeal. Ms. Coe, is there anything further?
Is there a specific number of days that before he can attend the rehab, just because he's not going to have any probation oversight? We'll have to deal with that directly. So I just wanted to put that in the notes.
Not putting a minimum on it, but it's amount of time and served. It's something that will have to take into consideration.
Thank you.
Mr. Trush,
Mr. Parrish, I will send the appellate rights over to you. So once you get them, just fill it out. I'll highlight the portions that you have to acknowledge and send it back to me. And then when you get that bed set up, notify my office so we can help you get everything in line here, okay?
Okay,
Okay, thank you. That's all for today, Mr. Parrish. The court's gonna disconnect at this time.
thank you, Your Honor.
Are you ready on Mr. Barshaw's case?
Yeah, sure.
People versus Barshaw, case number 225126.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Richard Church on behalf of Mr. Barshaw.
The record should reflect Mr. Barshaw is present here in the courtroom today. This is the date and time set for sentencing on a probation violation. Mr. Barshaw, did you have a chance to go through that report and talk to Mr. Church about that?
Yes, sir.
Mr. Church, are there any additions, deletions, or corrections?
No, Your Honor.
Are there any challenges to this wording?
No.
Spoke, do you have any additions, deletions, or corrections?
No, Your Honor.
The scoring.
No, Your Honor.
They not have to score their allocations, but
I think given Mr. Barshaw's behavior, basically just getting sentenced to probation and never coming back, the recommendation is appropriate with unsuccessful discharge. I'd ask the court to follow the recommendation. Thank you.
Your Honor, I guess it would indicate, I don't think the recommendation here is inappropriate. Mr. Barshaw will be the first to tell you, he was not being very smart. He was doing stupid things. He knew what his obligations were and he wasn't doing them because he knew what was going to happen if he did. If he was reporting like he was supposed to, he was going to get in trouble because he was doing what he wasn't supposed to. I do think it's important to understand and take into account, since Mr. Barshaw has been picked up, he hasn't made any excuses for what happened. He's been forthright and honest about it, and he's taken appropriate steps. The court may recall at the last hearing, he bonded out the day before the hearing. He still appeared for the hearing. He came here with an approval to go into a rehab. The court at that time did not allow him to go in and remanded him back to the jail. Since then, he's taken appropriate steps. He comes here today, having again secured a bed in a rehab so he could potentially go in. I would ask the court to take that into account in crafting what a sentence should look like. Mr. Barshaw needs rehab. He needs that. Again, he's going to be the first to tell you he was being a knucklehead and he wasn't being smart. He's also going to tell you he needs the rehab. A 9-month sentence is what's recommended. He has a little over, I think, 6 months of credit against it. It would seem an appropriate time to start looking at the rehabilitative side of this. So I would indicate to the court, I would ask the court to strongly consider that. He does have a bed secured at Great Lakes Recovery. He could go there as soon as 2 p.m. tomorrow. I've also prepared for the court an order regarding rehabilitation if the court is willing to entertain that. I do have a copy of that for the court.
If your honor is going to consider that, I hope the court doesn't, but if the court does, I would ask to extend probation, because when people go to rehab and they're not on probation, nobody monitors it. They can leave after the next day and there's nothing we can do. It turns into a procedural mess. Thank you.
Mr. Barshaw, you wanted to say?
Yeah, that's actually not even an option. I have absolutely no plans on coming back to here. That is correct. My mother again has driven down from Escondido, but she's tougher than any probation officer could ever possibly be on me. If I mess up, she's gonna drive my ass here. Like, no ifs, ands, or buts about it. And she runs Bay Pines prison. She's made it very clear to me if I mess up even remotely in the fact she's driving me back here. I've spent far too many years of my life high, and I need the tools that they offer there to even remotely, I don't even know how to put it in words. I need the tools to not get high. I've ruined my life every time I do.
I don't disagree with you. I'm certain that you would benefit from treatment, some intensive residential treatment. The question is, when is that going to happen? And I think the court's sending the wrong message, not only to you, but to anybody else who's on probation, that if you fail to even make any effort to comply with it, like you did, then I think there needs to be a price that needs to be paid. So within the guidelines of 9 months is appropriate punishment for your conduct. In terms of treatment, nobody needs to wait for a court to order treatment or to let them out of jail to go to treatment at any time that you want, really, anytime, after you're released. So I'm putting that all back into your court. If you really want treatment, then Great Lakes Recovery Center is obviously willing to take you. You don't have to make that a condition, or the court doesn't have to make that a condition for sentence. And I'm not going to allow you to be released early for that. Because again, there needs to be a punishment for your conduct in this case. And if you really want treatment, you're going to be released not that long of a time. You can go right to treatment as soon as you're released from jail. You can have that set up. And I hope that that is what we do, because I would agree that you keep that and I would benefit from it. But you need to follow through with the punishment here first. So the court is going to file the recommendation and sentence you to 9 months in the Crawford County Jail. You do have credit for 181 days served. The court is going to order that you be unsuccessfully discharged from your probation. The court will preserve any outstanding fines and costs. You do have the ability to seek an appeal of the sentence.
And I'm tendering. Fourth.
Mr. Barshaw, you already know. Next matter is with that's at 245. Mr. Maher, if you want to come forward, please, to the podium. We'll go on the record in People versus John Maher, case number 245354. The record should reflect Mr. Maher is present here in the courtroom today. Have counsel put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Richard Trush on behalf of Mr. Maher.
Thank you. Mr. Trish, can you tell me the status of this file here today?
Yes, Your Honor. The court may recall when we were last here, Mr. Maher had appeared via Zoom. We attempted to do a plea. I think we were about one question away and we had some technical difficulties. So we're here today. We still intend to take advantage of that offer, which was to plead to count 1, dismissal of count 2, as well as the operating without security and forfeiture of the weapon that forms the basis for count 2.
All right, Ms. Cope, just to confirm that's the correct statement of the offer.
It is.
Mr. Maher, I know we kind of tried to go through this before, but is that how you wanted to proceed today?
Yes, Your Honor.
Okay, could you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Mr. Maher, I know that we kind of went through some of this. I'm going to go through it with you again here today, just to make sure that there aren't any issues going forward. Are you currently on any kind of probation or parole?
No.
And you understand that by pleading guilty to count 1, which is possession of amphetamine, the maximum penalty is up to 10 years and a $50,000 fine. With that in mind, what is your plea to that charge today? Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you want it. You understand all those rights?
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading?
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it, you would have to ask for the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we said here in court?
No, Your Honor.
It's your own free choice to enter this plea.
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
The information I have indicates this happened back on September 28th of 2024. Is that the correct date?
Yes, Your Honor.
On that date, were you present here in Crawford County?
Yes, Your Honor.
While you were here in Crawford County on that date, did you have possession of methamphetamine?
Yes, Your Honor.
Did you know that that's what that substance was?
Yes, Your Honor.
Did you have any legal right to have any amount of it at that time?
No, Your Honor.
Ms. Coke, are the people satisfied with the factual basis?
Yes.
Defense is satisfied.
Ms. Coke, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Church.
I'm aware of none.
Ms. Coke, are the people satisfied that the court has complied with statute? Court will take this plea.
Yes.
Mr. Church.
Yes, Your Honor.
Mr. Maher, the court finds that your plea is knowing, voluntary, accurate. The court is satisfied that there is a factual basis to support the finding that you are guilty of this charge. The court will accept your guilty plea. Matter for sentencing hearing before you leave today. Interview. Ms. Coke, anything further that you need to address today?
No, thank you.
May I say something, Your Honor?
Sure.
I don't want to stand here and try to make you feel sorry for me. This is my dad. I haven't seen him in 25 years. I came out here to be with him. And he's had his addiction, right, for a long time. And that's part of the reason we've been separated, right? Like now that I'm out here, I can see in his eyes that he really wants to change and that he's cleaned up his act, you know. I can just see him. He's doing the program he's doing, and he's really trying hard. He loves me to death. He wants to be a part of my life. It's a bond that we never got to have, you know what I mean? And I mean, if any kind of leniency we could show on him, that would be great. Because I wouldn't stand up there and lie to you about something he like, if he was messing up, if he wasn't sincere, I wouldn't stand up here without, you know, he was my father. I honestly believe this man is trying to change, and he's seen the light.
Okay, thank you, appreciate that. Okay, thank you, that's all.
Your Honor, I did just want to make the court aware, Mr. Maher is in an inpatient program right now. He expects to be there for the next 6 to 8 or so weeks. So if there is some issue that we need to address to the court in terms of the sentencing, we'll do so, but I just want to make the court aware of it.
All right, thank you. Coke, did you want that flash drive back? Video?
Oh, I mean, I could take it so that we have a little drive, I guess.
Thank you. All right, we'll go on the record, versus case number 5343. The record should reflect the result present here in the courtroom today.
Jason Thompson, attorney for Jason Bolt.
Sierra Coke on behalf of the people.
This is the date and time set for sentencing this matter. Mr. Ball, did you have a chance to review the pre-sentence report and talk to Mr. Thompson about that?
Just now.
Do you need more time to do that before? we go
Oh, sorry.
Mr. Thompson, are there any additions, deletions, or corrections to that report?
No,
There's no guidelines. Ms. Pope, any additions, deletions, or corrections?
No.
One thing I do want to make full council aware, just because of what I read in the character letters and the report itself, I wanted to see what happened during this incident. Felt like everybody else has seen it except me, so thought it was important that I view it, given the kind of references that were made to it. So I just want the record to be reflect the fact that I did request from the prosecutor's office a copy of that video, the body cam from the officer, and I did review that. That being said, Ms. Koch, anything on behalf of the people for allegation?
Well, the court saw what happened. I really have no idea why Mr. Ball acted in that fashion. It was dumb. He obviously has some support in the community. There's a recommendation for no probation. We don't see that very often on an RNO or an attempt RNO. 15 days in jail with 2 days credit seems appropriate. I'd ask the court to follow the recommendation. Thank you.
Mr. Thompson?
Yes, Your Honor. We have a slightly different version of the narrative, but the court's seen it, so the court understands that, you know, Deputy Wyman essentially came out of the dark. It was surprising. I think Mr. Wolf largely complied, was complying, was, went to the vehicle and put his hands on the vehicle, was complying with the officer. And he started arguing, instead of continuing to comply with the officer, changed the direction from the have the hands on the car to the hands behind the back. And Mr. Wolf acknowledged that and pleaded, Your Honor. And he did not fully comply with that officer. He did not comply with lawful commands. I understand, given how loud Mr. Wolf was, why Deputy Wyman was coming in, probably more ready than he normally would be in encountering somebody. Mr. Wolf was at his home. He was obviously very agitated. What had been happening in his life was he has been on medication historically that helps treat his mental health condition. He had been experiencing a lot of insomnia and a lot of trouble sleeping. He went to his doctor and he said, and that's a side effect of the medicine, he goes to his doctor and says, Doc, I can't sleep. I don't know if it's the medicine, I don't know what's going on with the doctor. I think in hindsight, this wasn't the best approach. The doctor took him off that medication. So what you saw in that video when Mr. Wolf was so agitated, he had recently been off his mental health medication, not because he discontinued it, on his own, but because his doctor took him off it. And in hindsight, that wasn't the best approach. He's now back on it at a lower dose, but he's back on it. And he reports he's sleeping okay, and he reports he's not experiencing that kind of agitation that he was having that night, which was upsetting and scary. And he has been in the process of making amends with his family for being in that state that night and being so agitated that night. He's here today to apologize to the court and to pay his penance for not complying with that police officer that day, who was only doing his job. So he understands that. He is a hardworking guy. He's had some financial problems. He's going through a bankruptcy, a Chapter 13 bankruptcy, where you pay on your debts. So he is attempting to pay on his debts as best he can over a 5-year plan. It was interesting to me that there was no probation recommendation in this file, because Mr. Wolf is someone who's not too long ago had a very successful run on a probation. The court noted in his criminal history, he had a 2017 drunk driving where he successfully completed a 2-year sobriety court. So as the court is aware, that's a very intensive, it's like a version of probation, requires a lot of attendance, a lot of buy-in, a lot of compliance, and Mr. Wolf did that. So I think if the court ordered probation, he would successfully comply with that probation. I think historically, we can see that in 2017 in Oscoda County. Again, no doubt he was upset that night, that he was upsetting his family, that he was acting in a way that was concerning to the police officer, that he was, in my opinion, he was largely complying with the officer in that he did approach him, he did put his hands on the car, he was not attempting to assault or fight with the officer. He did then want to argue with the officer instead of doing everything the officer said, and that in hindsight was a very large mistake, which he is paying a price for. He is in this Chapter 13 plan. He works as a builder. He works essentially 5 or 6 days a week. Any jail time the court does impose, will be a financial reality to him. Will cost his family. And he understands he's the individual who's responsible for that. I just want the court to be aware of that. This isn't, he's not the kind of operation where they take winter months off. He is working still full time at this point. I would ask the court to consider probation instead of jail time because of Mr. Wolf's successful record with probation with Oscoda County. And I would ask the court to look at those character letters and consider perhaps what's reflected in those character letters is what he's like most days, when he's on his medicine, when he's doing well, when he's a productive member of the community, when he's working as a builder, taking care of his family. In the past, when he's been a firefighter, I would ask the court to weigh that more heavily. And then that night, when he was agitated and when he was, making a scene and not complying with the police officer, I would ask the court to consider, perhaps giving him some time on probation to prove that was an aberration, that his medication was not correct that night, and that he really can do better. Thank you.
Mr. Ball, anything you want to say today?
Yes, I do apologize for my actions that night. I should have, my son's a police officer, so I know how the stress that they go through. I should have listened. I was very agitated, and like he said, he was up on medications. It's not how I normally act, but I can't take it back. I do apologize to him. I apologize to the officer. I apologize to the courts.
All right, I reviewed the report, so familiar with all the information in that report. I did review the letters that were submitted on your behalf. And then, of course, as I said, I watched the incident itself. And I think there's a couple different factors at play here. I think, I could hear your yelling and screaming on that tape as the officer approached. That certainly is, you sounded to me like somebody who was kind of out of control at that point, and probably I think the family was well justified in calling the police, given that kind of behavior. That would be frightening, I think, to anybody. And obviously there was a lack of non-compliance with officers' orders. I think, it's easy to Monday morning quarterback. I think there could have been a better job of de-escalating with you when you're in that state of mind. People aren't going to respond well to aggressive behavior directed at them. They're going to tend to respond aggressively to that. But I think some de-escalation might have changed things, maybe not. I mean, you might have just been in the state of mind that you weren't going to comply with anybody, but I think it could have been more successful. But that's neither here nor there. I think in terms of what an appropriate sentence is, frequently with cases like this, where there's resistance, but not a lot of active physical resistance, we do order probation with jail time held in advance, and I think that's an appropriate way to deal with this. I think a short term of supervision for you with just some standard conditions of probation is more appropriate, and with jail time held in advance, so that if you don't comply with your probation, then what that tells me is, there's an issue here, you were given a chance to avoid it, and things like your job, all those other things don't matter as much to me anymore, because you've been given an opportunity to avoid jail by just complying with probation. So I'm gonna have you stay here for a minute, because we're gonna need to get one of the probation officers involved. Mr. Haven. Mr. Haven, I'm gonna order some probation for Mr. Falls, which is different than what the recommendation was, obviously.
Okay,
Uh,
the usual conditions.
a 6-month period of probation with the standard conditions.
Okay,
So you'll have 6 months of probation. Of course, it's gonna impose 30 days of jail. The court's gonna hold that in advance, so if you successfully complete the probation, you won't have to serve that time. However, if you violate probation, I can impose any or all of that 30 days immediately.
Yes, sir.
Up front. You have credit for 2 days served. The court is going to order a crime victims assessment of $130, or costs of $325, attorney fees of $350, state costs, along with the standard supervision fee,
yes, $30 a month.
$30 per month, supervision on probation. Because this is a misdemeanor, there are no written appellate rights. You have the ability to seek an appeal of the sentence. That would file the appropriate paperwork within the next 21 days. If you have any questions about that, Mr. Thompson. With that, should you want to file an appeal. Otherwise,
Is the probation mainly just for some oversight, making sure he stays in line, or do you want any counseling involved?
I think, that's a standard thing.
Well, it's for R&O charge, it's like just make sure he's staying compliant.
Right.
Okay.
Exactly. So just those standard things.
Okay,
Mr. Ball, if you successfully complete probation, you have to serve that jail time.
Yes, sir.
So make sure that you meet with Mr. Haven. Scope anything further to address today.
No, thank you, Your Honor.
Mr. Thompson.
Nothing further, thank you.
Thank you, that's all.
Thank you, Your Honor.
Yeah, if you want.
I'll talk to him and.
You